This is the matter of people of the state of Michigan versus Sean Michael Phillips. This matter arises based upon a request by prosecution and defense for our oral arguments on their briefs regarding the non-bindover from district court. I have reviewed both briefs, and I've reviewed several of the cases that have been argued in those briefs. Plaintiff, you are challenging the non-bindover prosecution. You would go first with your argument.
Thank you, Your Honor. Donna Pendergast, Assistant Attorney General on behalf of the people. Your Honor, I want to begin my argument by first pointing out something critical, because it is critical to this court's assessment on whether or not the examining magistrate, which in this court was district court judge in this case, whether or not the examining magistrate abused his discretion. Counsel has a critical error in his brief, both at page 12 and page 18. In two separate places, counsel quotes the case of Spalding versus Spalding to represent the proposition that the standard of abuse is so palpably and grossly violative of fact and logic that it constitutes an abuse rather than a use of discretion. I would suggest to this court that is old law. It's inappropriate standard. The standard was laid out by the Michigan Supreme Court in People versus Babcock, which is found in 469 Michigan 247, a 2003 case. And basically what the Michigan Supreme Court said in Babcock, they defined an abuse of discretion as follows. An abuse of discretion standard acknowledges that there will be circumstances in which there will be no single correct outcome. Rather, there will be more than one reasonable and principled outcome. An abuse of discretion occurs when the trial court chooses an outcome falling outside this principled range of outcomes. Your Honor, later in 2006, in the case of Schulich versus Richards, found at 273 Mishap, 2006, the Michigan Court of Appeals recognized that the Supreme Court rejected the Spalding standard cited by counsel and adopted the standard set forth in Babcock. Later in 2006, in Maldonado versus Ford Motor Company, the Michigan Supreme Court once again said, we reject the Spalding standard, and went on to say that the default standard is beyond the range of principled outcomes. I would say this, Judge, using either standard, it isn't even close in this case. There is an enormous amount of circumstantial evidence, more than any other case or fact pattern found in the case law that now exists in Michigan, in the Court of Appeals or the Michigan Supreme Court. I won't belabor the general law of probable cause, other than to say a few things. I know that this court has been on the bench for a long time. You've heard many motions to quash. You know what the law on probable cause is. But I would say this, Judge, probable cause does not require proof beyond reasonable doubt. The examining magistrate, which was the district court judge in this case, need not be without doubts regarding guilt. Beyond a reasonable doubt is a broad concept. I go on to cite other Michigan Court of Appeals law that says, and that is the case of People versus Hudson, 241 Mishap, 268. Certainty or confidence is not required on behalf of the examining magistrate before binding a defendant over for trial. The court must only entertain a reasonable belief of the accused's guilt. And probably most significantly, Your Honor, in terms of case law in Michigan pertaining to probable cause and the standard at a preliminary examination, is the case of People versus Hill, 433 Michigan, 464, a 1989 case. where Michigan Court of Appeals held that even if the evidence introduced at the preliminary examination conflicts or raises a reasonable doubt about the defendant's guilt, the magistrate must, and that is the key term, must let the fact finder at trial resolve these questions of fact. There is no question, Your Honor, based on the fact pattern that was put in front of Judge Wadle over the course of 3 days, that a question of fact was raised. I would like to go through Judge Wadle's opinion fairly sequentially, certainly not page by page, but just in terms of general propositions cited. Your Honor, Judge Wadle's opinion on page 1 and 2.
Give me a second to correct with you. I did review the opinion late last night as well as when earlier received. This is not a criticism. I do notice that in the prosecutor's copy, the pages of that opinion are not presented in order, but with that slight observation in mind, let me go through the opinion with you as you make your
All right.
points.
And that would be Appendix F, Your Honor. Your Honor, on pages 1 and 2 of that opinion, I was somewhat bewildered to see that Judge Wadle said there is minimal new evidence. I would suggest to this court that that is in fact an erroneous statement. Judge Wadle cited additional relevant facts. He cited 3 things. 1, the defendant was not previously violent with baby Catherine or her mother. 2, the defendant had a positive relationship with the older daughter, Haley. 3, the defendant was a custodial parent at one time. That is what Judge Wadle cites as the minimal new evidence in this case. I would ask this court rhetorically what any of those 3 points have to do with anything that needs to be determined by an examining magistrate. Let's start with the first point. Defendant was not previously violent with baby Kate or her mother. Your Honor, that is propensity evidence. Under Michigan Rule of Evidence 404, that type of evidence is not even admissible in a homicide prosecution unless there is an issue of self-defense. With a 4-month-old infant, I hardly think we have a situation in front of us where there is an issue of self-defense. So why would the district court, and I think it does go somewhat to show bias, bring up something that is not only not relevant, but not admissible under the Michigan rules of court as to that being one of the new pieces of evidence? Second,
And where you're saying these are offered as new pieces of evidence.
that was Judge Wadle.
Pardon?
That was what Judge Wadle said.
I've got pages 1 and 2 in front of me.
Right.
Are you still referring to something he said in the opinion?
Yes, sir.
Now, where does he line it up that way on page 1 or 2?
Page 1, Your Honor, and that would be line under facts, the 3rd line. It indicates most of the facts have been recited in the Court of Appeals decision. They will not be repeated here. Additional relevant facts brought out at preliminary examination include that defendant was not violent with Catherine, or for that matter, Ariel. 2, defendant had a positive relationship with their other older daughter to the point that he was favored over Ariel as the custodial parent. And that the defendant was the custodial parent at one point in time. That's the bottom of page 1 into page 2.
Right now, he describes those as relevant facts.
Correct. Newly, says there's minimal new evidence, and then cites those 3 facts. That is correct.
keep going with the argument. I'm not sure if we're tracking the same way or not, but keep going so I can get a complete feel for where you're headed with the argument.
So what the court says is there's minimal new evidence, and these are the only relevant new things that came out. None of the things, as I suggested to the court, are in fact have any bearing on whether or not the defendant killed baby Catherine. And in certain circumstances, whether or not, as I indicated, the propensity evidence, whether or not the defendant was previously violent, it's not even admissible. Now, what is significant and relevant and new that did come out at the exam? Your Honor, in its opinion, the court ignored 4 new things that came out at exam. The testimony of Deputy Baum, the defendant's seemingly prescient foretelling of the future, statement that he made to Dan Ruba that he could get rid of a body if need be and no one would ever find it. Number 3, the testimony of Rashawn Burton, never mentioned in the district court opinion. Number 4, the note written by the defendant from prison. That was mentioned in a different context, but it was not mentioned in terms of that being new evidence. But it was new evidence. It was evidence that has come forth since the prior trial. Your Honor, before I get into the facts of what is new in this case and why, I think I need to just in some way argue or bring up the fact that, you know, in every appellate brief that's ever been submitted on behalf of any party anywhere to any court, obviously the facts are going to be spun to favor your side. I do it, Mr. Glancy did it. So you have to look through all that to determine what's really going on here. I know Your Honor's been on the bench a long time. You've read a lot of people. And I think it's fairly clear from a read of the transcript that there are some unusual dynamics going on here between Ariel Cortland and the defendant. In fact, in the past, some people have interpreted that as perhaps her being involved in this, despite the fact that the police have done an extensive timeline and accounted for every moment of her whereabouts and basically ruled her out as being involved. But I think Dan Ruba probably said it best in the preliminary examination when he said Ariel Cortland had a sort of puppy love for the defendant. For lack of a better term, she has rose-colored glasses, and she wanted to believe with baby Catherine that things were going to be okay. And I think her testimony, and you've had the opportunity to observe her previously, I think her testimony to a certain extent shows that. But there are certain facts that are inescapable in her testimony. Even Ariel Cortland, in an attempt to put the best spin on things, admitted the defendant didn't want the baby. The baby Catherine was a financial burden. He suggested abortion and adoption. They had many arguments with the defendant stating that the baby would be a financial burden, that he threw away the birth announcements on 2 separate occasions. He never took the baby to see his parents, and in fact denied paternity to his parents. His parents did not know it was his child, and on the day in question, they had a severe argument about adoption right up to the time that the defendant took off with baby Catherine. Counsel in his brief at one point says, well, Ariel's testimony was that she was the one with the loud voice. Judge, the issue is not whose voice is louder. The issue is what they were arguing about. And they were arguing on the day in question right up until the time he took off with baby Catherine about the baby. So despite what Ariel wants you to believe, you have to look through to what has remained consistent in her testimony, and all of those facts are inescapable, and she testified to them in the transcript. That brings us full circle to why the testimony of Deputy Baum, which is new, is significant. Because Deputy Baum gives us an unobjective view into What's really going on with the defendant? How does the defendant really feel about this child, despite what Ariel Cortland wants to believe? Deputy Baum testified, and this is new testimony, when the defendant was served with paternity paperwork, he was mad. He was angry. He said he wouldn't pay, which goes back full circle to the arguments about the baby being a financial burden. In fact, the defendant's reaction was so pronounced that Deputy Baum felt it necessary to advise him, as a senior member of the military, of his obligations under the military code of conduct in terms of supporting dependents. I would suggest to this court that gives a real view of what was going on with the defendant, despite anything Ariel might want to believe that the future held for her and the defendant. Moving on to what else is new in this case, the defendant's prescient statement to Dan Ruba that because of his military training, he could hide a body and no one would ever find it. You know, Your Honor, in and of itself, that statement may not be significant. But when coupled with the testimony of Rashawn Burton, which was new, it takes on an added significance. What was the statement that the defendant made while in prison to Rashawn Burton? And I might add to this court, Rashawn Burton testified he didn't get anything to testify. He did it because he was thinking about his daughters and it was weighing heavily on him. Rashawn Burton indicated that he was talking to the defendant in prison, the subject of Kobe Bryant, Tiger Woods, and gold diggers came up. The defendant got angry. They were talking about women trying to get these celebrities money. The defendant became angry. The defendant said there was a girl trying to pin a baby on him, but that she wouldn't get a dime, and that he had picked the baby up and got rid of the baby, and they would never find the baby because they would never be able to charge him because they would never find the baby. When you take that evidence and look back at what the defendant said to Dan Ruba shortly before baby Catherine was born, I would suggest to this court the defendant did exactly what he said he had the ability to do, get rid of a body, and he admitted to Rashawn Burton that he had done it. He bragged about his ability to do it, he bragged about having done it, and he gave the reasons to Burton, saying, I did it because she's not going to get a dime out of me. I would suggest to this court that the testimony of Rashawn Burton is corroborative of both Ariel Cortland and the things that remain consistent in her testimony, as well as the testimony of Deputy Baum that the defendant was angry about being served with paternity paperwork. I would also suggest to this court that looking at all the cases in Michigan, that the testimony of Rashawn Burton alone, coupled with the fact that the defendant was the last person to have custody of baby Catherine, should be sufficient to establish probable cause under any standard of review. But there's more. Although the court, in its opinion, referred briefly to the letter that the defendant wrote from prison to Ariel Cortland, he didn't do so in the framework of this being new evidence. And Judge, I don't know what could be stronger evidence that baby Catherine died at the defendant's hands than the defendant's own words. Defendant, in his letter from prison, made multiple specific admissions about what transpired on the date of Catherine Phillips' disappearance. In his letter of August 7th, 2012, which was responsive to a letter that Ariel Cortland had written a short time before, the defendant starts with saying, okay, this is what you want, acknowledging he was answering the question Ariel asked, which was, what happened to the baby? He also says, I don't feel safe writing these things. The defendant in the next line of that letter describes his state of mind when he drove away with baby Catherine. He says, "I was angry." To use his words, "I was angry because the phone was ringing." He goes on to say, "I was angry for that day, for everything lately, for everything ever, maybe even." In the very next line of that letter, after saying he was angry for everything, the defendant refers to overt actions that he took. He indicates that he grabbed Catherine Phillips' car seat at the top and ripped it as hard as he could and said she was thrown. Your Honor, that is an overt action. That shows that we have had a loss. Whether or not that is criminal agency, and I will get back to that in terms of Judge Wadell's opinion, is a question of fact for a juror. But I would say this to the court. It would be a remarkable coincidence that an accident just happened to correspond with a time frame where the defendant admits not only being angry, but being angry with the subject that ultimately ends up missing. Once again, whether or not it was an accident is a question of fact. The additional omissions that the defendant made regarding the moments after Catherine Phillips was thrown do not describe a scenario consistent with an accident. The defendant indicates, rather than seeking emergency assistance or medical attention, he says, "I held her for a long time. It seemed like forever, maybe an hour, maybe a minute. It might not have been long. I can't explain a lot." That is not consistent with an accident scenario, Your Honor. The defendant goes on to say, "I never tried to help her. I used to hate myself for not trying." Once again, not only not consistent with an accident scenario, but baffling. I used to hate myself? After describing holding Catherine Phillips, the defendant states, "I think I was there an hour and that like," and I'm quoting him, "a half an hour, and it wasn't until right before I left I realized calling 911, which I would suggest to this court is an acknowledgement of some sort of emergency scenario that had taken place. The defendant goes on to describe his mindset at that time, indicating, "In a way, I felt like I had killed her. I needed to believe that I didn't hurt her, and this was all your fault." That sounds wrong, but I can't explain it. Once again, Your Honor, looking at the case law in Michigan and the types of statements made by defendants that the court has found sufficient to establish at least a question as to whether or not there is a question of fact, that in and of itself, that statement alone, I would suggest, is sufficient. But the defendant goes on. The defendant further describes, "I just drove. I pulled off the road. I needed to get out of the car. She was set in a peaceful place." The defendant admits leaving a 4-month-old infant somewhere remote in a peaceful place. And from the testimony that came in during the exam, we know Catherine Phillips' clothing was in his pocket, so he left her somewhere naked. And I would suggest to this court that there is only one reason to strip a 4-month-old baby naked, and that is to preclude identification of the remains should the body ever be found. At a later point in the letter, the defendant states, "It was like I was watching those things, not doing them." And I'm sorry, please excuse my language, but I'm quoting the defendant. "I wasn't dumping a body. It wasn't like that at all. No, it's not some fucking swamp or lake." This statement, I would suggest to the court, is consistent with somebody who knows they have committed a grave wrong. The defendant also makes a statement about his state of mind after arriving back home. He says, "I was thinking of taking my gun and leaving." The defendant makes that statement in the context of how he was feeling after just leaving a 4-month-old baby somewhere naked, alone. And I would suggest to the court once again, looking at the types of things that show a consciousness of guilt, wanting to leave with his gun, if he hadn't done anything, why? In his admission letter, the defendant also makes a number of other statements as to his thoughts after arriving at his residence. He says he was angry at his mother for bothering him again about calling the police back. Well, Judge, that suggests two things. Number one, his mother told him to call the police, and he hadn't done it yet. Number two, when she told him again, it was a bother to him. He didn't want to be bothered, and I would suggest to this court that being angry at someone for telling you to call the police back when any infant is missing, no less your own infant, is hardly behavior that's normal. The defendant goes on to say, I just wasn't ready to talk to anyone. I only wanted them to go away. And once again, looking at the case law in Michigan and what is equated with a consciousness of guilt, certainly that is a damning statement. But Judge, I think the next paragraph perhaps is the most significant at all, because the defendant says this: I just wasn't ready to talk to anyone. I only wanted them to go away. He goes on to state, and when that didn't happen, I thought I had committed to that story. To change it would be to throw away any chance I had. They wouldn't believe me because it was that day, and I figured it was a reasonable story. I would suggest to this court, not only does that statement in and of itself show that something was going on with the defendant that is consistent with a consciousness of guilt, but the defendant shows an awareness, a cognizance that nobody would believe his story, the unlikeliness of his story, so to speak. The defendant goes on to say, after the first couple of days, it seemed harder to do the right thing. And once again, I would suggest to this court that what the right thing is a question of fact for a jury. The defendant ends up by saying, I'm sorry that I lied about Catherine being okay. I wanted to tell you the truth for a long time. I blocked that day from my mind and almost refused to acknowledge it myself. So he admits that he lied about Catherine Phillips being okay. I would say to this court that contrary to the district court's pronouncement and the opinion that there was minimal new evidence, there was a lot of new evidence, and that letter to Ariel Portland in and of itself was sufficient to find the matter over.
All right, and before you pursue your next line of thought, recover what you're taking from the last part of the letter where you're quoting his comments about that day, up to that day. Tell me your take on that again.
Up to that day, I'm sorry, Judge.
Let me go to the letter. It's argument that you just presented, but I'm not memorizing it while you're saying it. So let me find the letter itself. What tab is that under?
Right on D.
Letter 3. It's an interesting statement, but what I'm looking for is your take on that, on what that tells us.
Your Honor, what I would suggest to this court is looking at the case law of a number of cases, which I'll talk about just a minute, the Ream Court, the Medalski case. Inconsistent statements that a defendant makes can be used to show a consciousness of guilt. Admissions that the defendant makes short of a confession can be used to show a consciousness of guilt. To refer to what you're asking as a general overview of that letter and what I believe it to be, I would suggest to this court that that letter is a series of disjointed admissions that lay out behavior and action inconsistent with the accident scenario that the defendant implies but never outright says. I would suggest to this court that The fact pattern of leaving a child naked alone in the woods, coupled with the statements about how the defendant reacted after she was thrown as a result of him ripping the car seat at, how the defendant acted when he arrived home, all of those are admissions which are not consistent with a non-guilty fact pattern, for lack of a better term, and are consistent and can be used to form corpus delicti. I would say to this court that in terms of whether or not admissions can be used to establish corpus delicti, which is roughly pages 3 and 4 of Judge Wadel's opinion, we agree. That's one thing that I agree with the district court on. Any admissions made by a defendant can be used if they're short of a confession of guilt, which clearly in this case the defendant does not admit culpability, but admissions can be used to constitute corpus delicti.
I haven't been able to find the language that I'm asking you about, and I am trying to listen to your argument, as I also tried to find the language that you're questioning, so I think I'm still following.
Okay, so would you like me to proceed?
Argument. Help me find the language in his letter that you were referring to earlier, where you said, again, unless I have the court reporter quote what you were saying, I want you to recover what your statements were about that part of the letter.
Okay.
I'm still struggling to find it in the letter. It's a little bit hard to read.
Yeah. There is a translated version behind it, Your Honor, a typewritten version. That may make it easier for you.
What tab is that under?
That would also be under tab D, behind the handwritten version. Judge, are you referring to one specific admission, or do you want me to refer to each page? Because the quote that you were asking about, when that didn't happen, I thought I had committed that story, that's found right below the top of the page on page 3 of the typewritten version.
All right, I'm still struggling to find that. No, maybe this is part of the problem. On your judge brief, there are 2 tab Ds, and 1 tab doesn't have anything behind it. And maybe that's where it was intended to be.
Can I approach the bench?
Yeah, let's see if that straightens us up here.
Would you like me to go through the admissions that?
Yeah, no, not yet.
Okay.
I've still got one goal here that hasn't been accomplished yet. I think I'll take up more time than necessary.
Your Honor, if it would help, I've just, while you've been looking at this, I've come up with the specific lines in the typewritten version for the first 4 or 5 admissions that the defendant made, and Mr. Spaniella can continue to get those lines if the court needs to be pointed directly to them for the rest of them in the next few minutes. If the court wants me to proceed.
What I'm doing is, you were putting an analysis on a line that I thought was of interest, but I was going to have you repeat what it was that you were saying, because I'm not able to locate the line that you were describing. If I had that in front of me, I would say, now this is the line, and repeat what you're trying to say about that line. If Prosecutor Spaniola has already located what he feels that I was looking at, that's fine.
Well, Judge, I'm not sure what you found of interest, but I can go through the admissions again and indicate where they're located, as far as I've gotten so far, and then you can attempt to look for the other ones. Well,
Okay, I'm not sure what, it's kind of like trying to analyze something that you really don't know what you're dealing with. Just continue with your chain of thought, and maybe at some other time I'll decide if I need the court reporter to go back and cover some of these things that you just said a few minutes ago. Go ahead with your line of thought.
to summarize those, Your Honor, in its totality, the defendant's letter to Ariel Cortland from prison lays out a number of admissions that are, once again, inconsistent with an accident scenario. But probably most significantly and most importantly, the defendant admits that he took overt action, and that's found on page 1, line, I'm sorry, you might have to take mine. On page 1, line 23, 24, and 5, the defendant, after indicating he was angry, says, the car seat, he's talking about the car seat, I pulled, it was jammed between the seats, that made it worse. I grabbed it at the top and ripped it out as hard as I could. She was thrown from it. I didn't know. I'm sorry. Once again, I would suggest to this court Whether or not it was an accident scenario is a question of fact, but the defendant admits to overt action that caused the death of baby Kate, because subsequent to that admission, he indicates she was thrown, I held her, basically indicates he drove around, he got out of the car, he walked away, and he left her somewhere peaceful. Your Honor, once again, Judge Wadle and I agree that admissions of a defendant, and in this case I would suggest that they're admissions that are inconsistent with any non-culpable scenario, especially under the fact pattern that was occurring on that day. For lack of a better term, things had reached critical mass on that day. On the day in question, the defendant had gotten his paternity his paternity DNA test. He was Ariel Cortland and the baby were scheduled to get theirs, and the defendant knew that he had been representing to his family, family members, that this was not his child. He knew as of that day the die was cast. He would no longer be able to deny paternity. Looking at the case law in Michigan in terms of admissions being used to establish a corpus delicti, that is unequivocal. The case law in Michigan is clear in that. But I would suggest to this court that the judge's opinion in this matter, saying, well, you have two stories from the defendant. Well, actually, there are many, many stories from the defendant. The defendant first told his mother that the baby was with Ariel Cortland. He next told Officer Skiba that the baby was with Ariel Cortland. He told Officers Custer and Under Sheriff Hartley the baby was with Ariel Cortland. Detective Posma, he told him multiple times that the baby was with Ariel Cortland. So there's a whole series of lies right there. But I would also suggest to the court that the defendant's two statements, one where he planted a note in his jail uniform suggestive of some sort of adoption scenario, a scenario which he repudiated later with this letter to Ariel Cortland from prison. The judge says, oh, well, the defendant gave two stories, and so you have no criminal agency here because either is equally probable. And I would say this to the court, that proposition in and of itself is absurd. I am not required to take a defendant's self-serving statements, a person who admits to multiple lies, at face value. What the Michigan courts have said in a number of cases determining whether or not admissions of a defendant are sufficient to establish a corpus delicti, they have found that inconsistent statements are indicative of a consciousness of guilt. Because if you're telling the truth, you have no reason to tell different stories. What I found troubling in the court's opinion is the court says two things. He says the jail letter scenario that suggests an adoption is part of the prior record of the case, and the prosecution, second, is trying to repudiate the evidence that it relied on in the proper case. I would say two things to this court. Number one, the court may narrow it down. It cannot rely on anything outside of the current record. Second off, far from trying to repudiate evidence that was admitted in a prior case, I put the evidence in. The evidence that a note was found in his jail uniform suggesting an adoption scenario for a reason. Because in keeping with prior Michigan law, the fact that a defendant has told multiple stories, the courts have found to be indicative of a consciousness of guilt. And the fact that he suggested an adoption scenario that he later repudiated in his letter from prison to Ariel Cortland shows that the defendant has a number of stories, and in keeping with Michigan case law, that is indicative of a consciousness of guilt. Your Honor, what I would suggest to this court is that where Mr. Glancy, as well as the court, erred is, and what is the standard for establishing corpus delicti under the law in Michigan? And I have cited a number of cases, there's not that many of them, but a number of cases as to what constitutes corpus delicti under Michigan law. The judge in his opinion says you have to have specific loss. We have it here. Defendant has admitted baby Catherine was thrown, he held her, he didn't call 911, and he left her somewhere peaceful. But the question is, was there criminal agency? Where the court and Mr. Glancy, in relying on old case law, in the case of People versus Williams, I believe he referred to, what they failed to see is the case law in Michigan unequivocally says you do not need direct proof of the criminal agency. Circumstantial evidence and reasonable inferences to be drawn from that evidence is sufficient to establish the corpus delicti of the crime. I laid out in my brief a number of corpus delicti cases, but that has always been the law, way back to the first no-body case that shows up in Michigan case law, the case of People versus Modelsky. In Modelsky, the only facts that the court had, and this was affirmed, a conviction was affirmed on these facts, the defendant could not be located. The mysteriousness of the disappearance, the fact that the defendant had a motive to kill, the defendant's actions after the victim's sudden and unexplained disappearance. That was all they had in the Modelsky case, Your Honor, and the court found that that was sufficient to sustain a higher burden in the light most favorable to the people at a jury trial, not just a probable cause burden. In a more recent case, the case of People versus Ream, the 2010 case from East Point, this was the only facts they had in the first-degree murder case. The defendant, who was the father of an individual, the defendant phoned the victim, who was a friend of his son's, and asked her to meet him at Dairy Queen. The defendant asked her to meet him at Dairy Queen because his son was having a birthday party. The son of the defendant's birthday was not in April, the month of the disappearance. It was in January. The son's mother testified she was not aware of any party on that date, and the defendant had made arrangements for his son to be out of town on that date. Defendant subsequently made some inconsistent statements. He didn't know the victim, then said he did. In affirming a first-degree murder conviction, the Court of Appeals found that not only could a reasonable jury find that the defendant deliberately lured the victim to Dairy Queen, but that when doing that in conjunction with the other circumstantial evidence, they can infer premeditation as well. The Stewart case, which is cited on page 27 of my brief, likewise, pretty much the only evidence other than the defendant's inconsistent statements was that the defendant created a fake alibi and made a statement about it being done. Your Honor, when you stack the facts of the present case up against Modelsky or Ream or any of the case law in Michigan, I would suggest to this court that we have volumes more. It is uncontroverted, especially in light of the defendant's prison letter, that the defendant was the last one with baby Catherine. Neither the Ream case nor the Modelsky case did you have any statements from the defendant that implicated themselves, in the disappearance in any way. In this case, we have two. We have a statement to Rashawn Burton that a woman was trying to pin a baby on him and that he had gotten rid of the baby and she wouldn't get a dime. We also had the detailed letter from prison, which I've gone through ad nauseum, where the defendant not only admits doing something that caused a series of events that killed Catherine, but he also admits to behavior inconsistent with an accident scenario. I guess, perhaps, Judge, the most important and pertinent part of this entire argument is Appendix G. And I certainly hope you have that. Appendix G is the People versus Nelson case, and I know Mr. Glancy referred to that in his brief, and I'll talk about the facts of that case in just a moment. In Nelson, there was a no-body case where in a bench trial, the circuit court convicted. The Court of Appeals reversed for insufficient evidence, the Michigan Supreme Court reversed the Court of Appeals and said these words, and that is an appendix to your brief. Even absent concrete proof of a particular act causing death, the circumstantial evidence was legally sufficient when viewed in the light most favorable to the prosecution. That is the exact language of the Michigan Supreme Court. Even absent concrete proof of a particular act, which is directly contradictory to what Judge Wadel said in his opinion, that there was no direct proof of a specific criminal act. What the court has said, they refuted the proposition that you need direct evidence of a criminal act, but that you have to look at the totality of the circumstances to determine if there is sufficient circumstantial evidence. And that's where Judge Wadel erred, and that's where Mr. Glancy erred. Now, the Nelson case, I would suggest to this court, not only did the Supreme Court find that circumstantial evidence can be sufficient to establish corpus, that was for the purposes in the light most reasonable, most favorable to the people, which is a much higher burden than the probable cause burden that Judge Wadel was supposed to be assessing. You know, Judge, I did an extensive corpus delicti brief before we ever went to preliminary examination, and I have the Nelson case in there. And you can't just disregard a pronouncement of the Michigan Supreme Court because you don't like it or don't agree with it. They have unequivocally said you don't need direct proof of a criminal act causing death, just sufficient circumstantial evidence. I would suggest to this court a question of fact was in fact created. What is the totality of the circumstantial evidence in this case? The defendant wanted to give baby Catherine up because she was a financial burden. There were frequent fights about the issue between Ariel Cortland and the defendant. The defendant never acknowledged paternity to his family and never brought baby Catherine around his parents. That things reached critical mass on the day in question because the defendant had already gotten his blood test, and once the baby was tested, there would be no denying paternity. That the defendant made one last attempt to facilitate an adoption, driving Ariel Cortland and the baby to the Department of Human Services rather than to the hospital for their DNA test. That this argument over adoption was taking place right up to the time that the defendant drove away with baby Catherine. Uncontroverted in his own words, the defendant was the last one to have baby Catherine. That after he drove off, he, for lack of a better term, went off the grid for 2 hours before he surfaced again. That when he was questioned as to baby Catherine's whereabouts, he lied to his mother and he lied to Officer Steve on the phone. That he also lied to Under Sheriff Hartley and Sergeant Custer at the house, saying baby Catherine was with Ariel. That he had the clothes that Catherine was last seen in his pocket. The car seat.
Can you describe whether those clothes were, so to speak, whether they had been in water or not, or whether they had been in mud or dirt or not?
They did not appear to be, Judge.
They appeared to be
Fresh.
removed while still fresh.
Correct. There was no testimony that they were in any other condition, yes.
Keep going.
That he had the car seat that baby Catherine had been in the trunk and a used diaper under the seat. That when he was interviewed by Detective Posma, multiple times he lied and said that the baby was with Ariel. That he later concocted an adoption scenario that he admitted was untrue in his letter to Ariel Cortland when he said, "I'm sorry, I lied about Catherine." That he made admissions to Rashawn Burton that some woman was trying to pin a baby on him and he had gotten rid of the baby and the baby would never be found. That he wrote a detailed letter, self-serving as it may be, that indicated that as a result of actions that he took, that baby Catherine was in fact thrown from a car seat. Your Honor, the Nelson case, I just want to cover briefly. I'd suggest to this court that counsel has said, well, this is an example of what can happen, because Nelson was ultimately sent back from the Court of Appeals to the circuit court for a new trial with a new judge. In remanding that case back, and that's a whole convoluted fact pattern, nowhere similar to the fact pattern that we have here. But in remanding it back, the Court of Appeals acknowledged that the law of the case stands in this situation. And what is the law of the case? The law of the case is the Supreme Court pronouncement that that fact pattern in Nelson, even absent concrete proof of a specific act showing criminal agency, that the totality of the circumstances were sufficient. The Supreme Court laid out the standard. The Nelson pattern, the fact pattern, all they had in that case, you had the defendant who had an overt bias against African Americans and was very vocal about it. You have the defendant being seen with the victim on the night of her disappearance, and the defendant made a number of inconsistent statements. The case, once again, was the circuit court convicted in a bench trial, Court of Appeals reversed. Supreme Court reversed the Court of Appeals and sent it back for consideration of other issues. And then based on a stipulation by the prosecutor, the case was sent back to the circuit court because of newly discovered evidence. That's all they had in that case. And the Michigan Supreme Court said that is sufficient circumstantial evidence in the light most favorable to the people, which once again is a much higher burden. Your Honor, I've laid out the totality of evidence in this case, and I would suggest to this court, I can't imagine a scenario where there would be more evidence short of the defendant confessing, yes, I did it on purpose because I was mad. You have multiple admissions. You have a statement to an inmate. You have a fact pattern which is totally inconsistent with accident. I would suggest to this court that it would be patently unfair and contravene public policy to allow a defendant to reap the benefits of shrewd behavior, disposing of the evidence of his crime. The evidence in this case was more than sufficient to establish a probable cause burden, and I would ask that you reverse Judge Whale. Thank you.